So like I was saying, I believe you can all see 6 justices here, together with myself as the Chief Justice. I must let it be known clearly that my job here this afternoon is to oversee what is going on here. The remaining 5 justices are going to be manning today's court hearing. Myself as the Chief Justice will only come in when the need be. Please, can you hear me? Okay, so I was saying that I'm sure you can all see 6 justices on the bench right now. Myself as the Chief Justice here is more or less playing a supervisory role in today's hearing. The other 5 justices are the ones going to man today's hearing. However, I only come in when the need be. Please, are we all clear? Okay, so like I said, we have 4 cases. The Clerk of Parliament will read out the cases, starting from case number 1, which is a petition from Mr. Mesu Washington, who is the lead petitioner, and Mr. Japon Akrasi Stephen. This petition was received by the Chief Justice at 10:46 p.m. on the 7th of August 2021. Let's take note of the time and the date of reception. And I would also want to use this platform to let this be in the form of an announcement. Usually, before we receive a petition or a suit, it has to go through certain appropriate channels. First of all, you need to write to the Judiciary Secretary. She receives it, sends it to me to acknowledge reception. Then I instruct her to let you know that we have received the petition. It comes to the bench. Then we look at the merit of the case and make a ruling as whether we are taking it or not. If you send a petition to me at 10:46 and expect the bench to call for a hearing the following morning at 8, that is illogical, and I'm sure you all bear witness to that fact. So please, I'm on several pages, and I must confess, I read a lot of unfortunate messages. You don't expect to submit a petition at 10:46 and let us do magic and call for a hearing the following morning. It's not like we are all, staying awake throughout the night. It was rather fortunate you met me at that 10:46, so I received it. On a normal day, I shouldn't have even received it because 10:46, I could have directed you to my secretary, but I took it. And you go and sit on a platform and be saying all sorts of things about the bench. I think you are not being fair to the bench. So please, moving forward, let's take notice of all these things. We are all students, first and foremost. If you submit a petition by this time and expect us to go for a hearing the following morning, you are not being fair to us. You don't just wake up and slate a date and time for hearing. We need to sit on the case, look at the merit of the case, and call for whether you're supposed to even hear it or not. You don't expect us to work magic after receiving your petition at 10:46. So please, those of us who are fond of that, let's be careful with some of these things. Thank you. So the Clerk of Parliament the Clerk of the Judiciary Committee would read the petition, then we move. Thank you.
University of Health and Allied Sciences, AMB 31 Hall, 7th August. August 2021, the U.S. SRC Court of Justice Hall. Attention, a contempt against the U.S. SRC Court of Justice. in pursuant to Article 3, Clause 3, titled Enforcement of the Constitution, it stipulates that failure to obey an order or direction made or given under Clause 2 of this article constitutes a violation of this Constitution and contempt of the Court of Justice, and shall, in the case of the executive officers, constitute a ground for removal from office. The UHAS SRC Constitution is the supreme governing book of the Student Representative Council. We humbly write to the UHAS SRC Court of Justice on the contempt of Team Sunny Days moved on the UHAS SRC Constitution and the Court of Justice. On 6 August 2021, prior to ending the UHAS SRC general election, the Office of the Chief Justice of the UHAS SRC served a letter to the Office of the Electoral Commissioner, specifically laying an injunction on the declaration of federal SRC candidates' results. There have been many circulars from the camp of Team Sunny Days with the title, Outcome of SRC Local News Election Results Presidential, declaring the results that defiling the injunction placed on the declaration of the results by His Lordship the Chief Justice of the UHAS SRC Court. We find this as a contempt and must be addressed appropriately. We humbly implore the Court to, as a matter of urgency, act on this contemptuous act from the said team. We are counting on your cooperation. Thank you. Matthew Washington and Japan Akresi 7.
Do you have the petitioners here, please? Petitioners for case number 1. There were 2. Where is the other one? Kindly move forward, please. 2, and I'm seeing 3 common. Pardon? Okay, please sit. Okay, so I think we need some clarifications here. Okay, in as much as we are all students, the university is a learning process, and we want to make certain clarification here. The title of this petition is Attention, a contempt against the UHAS SRC Court of Justice. I don't know who the defendant is in this petition, and where we sit as justices of this university's SRC, you don't call the attention of the bench for them to see something. Are we on the same page? Okay, I think I have to calm down. So we are the bench comprising of 8 justices. If you realize there is a contempt, we don't need a student to tell us. We would subpoena the person to come and answer questions in court. Are we making headway? Are we making headway? Okay, so let's come to the Ghanaian setting. The Supreme Court will only subpoena you for a contempt act when the bench realizes what you've said, what you've done, or what you are doing is contempt against the bench. No citizen can write to the Supreme Court and tell them that citizen A is acting untoward or acting contemptuous to the Supreme Court. Is this also clear? Please, am I making myself understandable? Okay, so what I'm trying to say is that this should have come from the bench. Attention, a contempt against the U.S. SRC Court of Justices. The Court of Justices are fairly represented here, and if we had realized any contempt act on any party, we would have subpoenaed that party. Are we all clear? Are we all clear? So that is a bit of education I want us to know. It's not a discussion. Please, take note. It's not a discussion. This is what we have decided as a bench. I would also want to give the platform to my other justices to let them tell you what they also make of this petition.
Good afternoon. I am Mariam Former Quadra, one of the justices here. So this petition also means that in our Ghanaian settings, when you are talking to somebody, you need someone to tell you that the person you are talking to is insulting you until you know that. No. So this is exactly what the one writing this attention does to us. Is telling us that the people we are working with are insulting us. But this petition, it's not even a petition. We don't know what it is. Whether it's a letter, a petition, or whatever. We don't know how to categorize this. So, in order to be fair, we just decided to sit on a case and hear your views or hear what you have to say. But in actual fact, this is not acceptable.
Okay, so that is what she clearly stated. Sure, you might be wondering why we think it's not a contemptuous act. Okay, so when you take the Constitution, the mandate of results declaration is the outright responsibility of the EC, as seen in Article 38, Clause 8. Okay, we gave an order to the EC not to go ahead and declare the results for only the presidential portfolio, right? I'm sure you all saw the injunction letter. Yes, it would have been a contempt act, assuming without admitting that the EC went ahead and declared the results. That is what would have been a classical contempt. Are we getting it? So if someone sits somewhere and posts a result, and you are drawing our attention to the fact that it's a contempt against the SRC Chief Justices, it's so not. It only becomes a contempt act when the EC, after being injuncted, went ahead to what? To declare the results. That is the only case it would have been a contempt. But from where we are seated as justices of the SRC, we feel the Constitution, which is our guide, this case is of no merit, and we strike it out of court. Kindly take your seat, please. Kindly take your seats, please. Case number 2. Once again, we are not in a discussion room. We have made ourselves clear as to why we feel this case is of no merit. We've explained to you the facts of the matter, and our conclusion is we are striking out this case from court because it's of no merit. Once again, if you feel aggrieved after this verdict, you have the right to appeal as found in our SRC Constitution. Thank you. Case number 2.
Case number 2, Mr. Philip Cosmos Bubunyo, PO Box 299, Frocon, Ikapim. The Chief Justice, U.S. SRC, for 6 August 2021. Dear Sir, still challenging the credibility of the voting software. It is a pleasure to seek redress from your high office. I have credible evidence to prove to your law court that the voting software used for the SRC elections has been compromised. The constitutional instrument used by the Electoral Commission in these elections read from Article 12 that the electronic online vote casting system shall be used since it has proven to be effective in the past SRC elections. Unfortunately, this was not the case, as my suit will seek to establish that the voting system can be breached. We have evidence to suspect wrongful doing that has the potential in affecting the electoral results. From one of the official election updates that was set as a picture on social media platforms, the EC stated how the voting was to be done. It wrote, input your index number and PIN with in the link sent. However, this was quickly changed in a communique dated 3 August 2021, which read, the Commission has resolved to the usage of student-specific index number and portal password for the voting process tomorrow on the 6th August 2021. All the above communiques have been duly attached to our suit, and our evidence has been gathered to prove our case. We have reason to believe that the changing of this PIN or password procedure created room for the voting software to be manipulated. Again, we have evidence to prove to your high office that the portal password used in the election was unfortunately and effectively breached. On the above premises, we pray the court to grant our following prayers. 1. Lay an injunction on the electioneering process until this matter is satisfactorily investigated. 2. That the EC be tasked with finding a credible and secured voting software for its elections. 3. That a new and fair elections would be organized by the EC to serve the interests of the SRC. Cosmos Bubunyo, lead petitioner.
Is the lead petitioner here? Before that, let's take this quick announcement.
Okay, so a motion was written to the bench, and it says that it seeks to reduce the number of justices on the bench. However, this issue has been addressed by the CJ. When you read the Constitution in Article 52, it states in Clause 1, it states, except in impeachment proceedings, the Court of Justices shall be duly constituted for its work, but not less than 5 justices. The justice of the SRC Court shall preside at sittings of the court, and in its absence, a justice nominated by other justices of the court shall preside. In all matters specifically provided to the contrary, the decision of the Court of Justice shall be by a simple majority, and hence, if the Chief Justice is presiding over the case and there are other 5 justices, the votes are passed on to the justices, whereas a majority decides who actually with what the majority actually decides what direction the case moves. In this case, the Chief Justice here is just playing a presiding role. So the other justices are the ones going to take votes, and when it is majority, it moves on or wherever the decision goes to. I hope we are clear.
I think this was early on addressed, or okay. So, lead petitioner, before we start, kindly stand, please. We didn't ask you to sit, and you are seated. In your suit, you made mention of the fact that you attached something. I want to read. All the above communiques has been duly attached to our suit, and our evidence has been ordered to prove our case. I received this suit on the 7th of August at 5 p.m., but there wasn't any attachment. It came with just this letter in a brown envelope. But you stated categorically that all the above communique has been duly attached. I didn't see any attachment. Yes, I haven't called you. Kindly get back.
Your Lordship,
I haven't called you. I'm still talking with the petitioner. Please. You don't come forward until, of course, you are being called. Please, get back. Don't be talking to the petitioner. I don't know where you are, so get back. Kindly go on.
Yes, I meant to remove that particular statement before sending, but it seems I corrected, but I printed the wrong one and brought it, so I'm sorry for that.
So which one do you want us to strike out?
The attachments, I have them here.
So I should strike out all the above communique has been duly attached to our suit. Our evidence has been gathered to prove our case. Should I strike it out?
Please, the communiques are here, but I didn't attach it to the letter.
Can you finish the office of the court with this?
Please come again, I didn't hear you.
Kindly finish the office of the clerk with your attachment and label them appropriately, please. Kindly take your seat, please. Kindly take your place, please. Seat, please. Petitioner, do you have any other evidences to submit before we start?
Yes.
Do finish and collect with those.
I would like to invite my legal counsel.
Are you here on yourself or you have an attorney?
I have an attorney.
Kindly introduce our attorney to
Okay,
the bench.
Mr. Imran Kovnabwat.
You can take your seat.
Thank you.
Your Lordship, I would like to
Kindly
address
take
the
your
bench.
seat,
Thank
please.
you very much.
Kindly take your seat, please. We'll get back to you. Hello. Okay, so I'm sure you are. VC, kindly sit. Please sit. VC, sit. VC, if you don't want to sit, leave my court, please. If you don't want to sit, leave my court, please. If you don't want to sit like how others are sit, Hansen, please sit. Don't shake that seat, please. Put it back. Listen, I'll be forced to sack you from my court. I'm serious. That seat is not meant for the audience, please. I'm sure we are all wondering why we are having discussions amongst ourselves. And it's all because of how some of the petitions or suits are being crafted. We are even now calling to, because some of these things, before you write a petition or a suit, at least seek legal guidance. Please. You're making it very difficult for us to, all that we are doing now is to assume the suits and petitions are very vague. You bring a suit